You asked him for more coffee for me?
Okay, thank you so much everyone for joining us, and a really warm welcome to Malavika ma'am and Justice Prabha, both of whom are just people I think all of us as younger feminists in the legal space, as lawyers, as law students, we've all looked up to a lot. I know I certainly have, and every time I've heard them speak, it's been an absolute pleasure and a great learning experience as well. So I'm very excited and glad to be able to moderate this and to also be able to listen in. So I'll just go ahead and introduce them, though obviously neither of them require any introduction. But yeah, we have Ms. Malavika Rajkotia with us, who's going to be our speaker. She's been an advocate in Indian courts for over 35 years, and she's developed a practice on divorce and property law. She is widely regarded as one of the best divorce lawyers in India. She's also the author of Intimacy Undone, which I've been reading actually throughout. We've all been reading through our project because it's just very insightful in terms of just how she examines the institution of divorce and marriage in India and how she brings in her own life experiences, both as a woman and a feminist, as well as a lawyer, and blends that with sort of the development of case law, the broader constitutional debates around women happening, and broader questions like around love and gender and just the institution of marriage, the UCC that seems to constantly loom up over our heads every few years, and right now seems more looming than ever. Um, so yeah, we will be having her speaking about the recognition of women's economic rights, particularly within the context of family law and divorce and women's unpaid work. And as a discussant who will offer her comments, we have Justice Prabha Sridevan joining us. She served as a judge of the Madras High Court from 2000 to 2010. Post retirement, she was appointed as the chairperson of the Intellectual Property Appellate Tribunal. During her tenure as a High Court judge, Justice Sridevan dealt with a wide range of cases, including the celebrated Novartis Glivec case, where she ruled against Novartis, holding that India's Section 3D was a constitutionally valid statutory provision. Justice Sridevan also, of course, um, gave the Geeta Hariharan versus RBI judgment, which I think a lot of us have read in the context of just how to do feminist judging in difficult contexts. Um, and it's, I think, one of the only judges I've heard call herself a feminist, which is otherwise, difficult to say in these areas of practice, as we all know. So yeah, over to you, Malavika ma'am. Please go ahead.
Right. Thank you, Amala. I always feel quite overwhelmed by these kind of introductions. And let me tell you, one of the reasons is because in my head, I'm actually not as that old. I'm actually in my head, I still think of myself as about the same age as you. And I think Justice Sridhavan will probably agree with me. Now, what I wanted to say, this talk has been in the context of the High Court of Madras judgment on visibilizing women's labor. And my point in that is that it is indeed a remarkable judgment, but the problem we must always remember as we look to evolving jurisprudence, that we might have judgments of the nature of this one or ruling such as Justice Sridevan has ruled in the past, which we will also be referring to on the value of a woman's work, that law of precedent and the contribution of it in an evolving jurisprudence is always the possibility that there can be a conflicting judgment. So it is good that we had this particular judge who thought this particular way, and we have this very important judgment, but it could well have been not. And that is the problem in judges who then are ruling obviously from a space of personal socialization. So this is important when we are talking of margins of discretion and evolving. Now, why does that happen? According to me, it happens because the default position where we start talking women's rights from, that there's a power asymmetry in the default position. Now, power asymmetry is a sociological reality, it is true. But when we are talking about it in court, then surely the constitutional default position should be one of equality. Amala, you have put off your camera. Can I see you? Because otherwise it's a little disconcerting to just.
Yeah, yeah, sorry. It's back. I completely
Yeah,
understand.
yeah, thank you. Thank you, Prabha. So, so therefore, according to me, the role of a judge is the starting point of the default position in women in the power structure has to be equal. And judgments suffer when we are only working around those default positions to make it less unequal. And that is the problem. Now, here the default position is yes, they are equal. They do many things. Women are equals for a number of reasons. Now, in this particular case, the fact is that the husband was in Saudi Arabia, he was sending money, she was investing it, and so on and so forth. Because then we come to the next problem. What is woman's labor? So, is it only invariably it gets pushed into domestic labor? And that somehow becomes almost like a supporting role rather than a primary, as important and equal role. So if we removed it in that default position while adjusting that, then we recognize that whatever she does, be it in the domestic sphere or be it as a co-earner earning as much, maybe more, maybe less, but the truth is that she is equal, then the approach would perhaps be more beneficial for women. And judgments like this then would not be a rare, remarkable occurrence. They should now be the norm to 75 years after independence and after the constitution having come into effect. Because the constitutional position is that she is equal. Now we look at her equality within the family, which is what the judges have to do. And therefore, it means acknowledging her as an equal, not just as in the supporting role. So, to make my point, what is remarkable about this judgment is that it treats her as an equal, albeit in this set of facts. Something that no judgment in the past has acknowledged completely. And with the greatest of respect, and I think I'll wait for what Justice Sridevan has to say about this, but even while going over her judgment, which is just, where is, yeah, the national insurance case, I have it here. Now there in paragraph 14, while assessing the value of her work, the judge says this can be justified. So is that she was assisting her husband at work and taking into account the notional income of a housewife, we confirm the monthly income of so much fixed by the tribunal. This can be justified by adopting the partnership method and assessing her salary at half her husband's salary. Now I can understand this is half her husband's salary in terms of a claim from the state. And this was in that context. So I understand that it is in this situation, but we need to mark that question as to why it was half, as computed as half, number one. The other judgment which is treated and which I too have relied on for better maintenance rights for women is Anurita Bora. Do you have that here? Anurita Bora's judgment, Justice Vikramjit Sen, basically has just, I don't think it's here, has said, however many claimants in a family for maintenance, the family resource case to be divided into that many number of claimants with an extra share for the husband because he is the dominant earner. So my notes, the ones. So if it is an extra share, we are recognizing him as the dominant earner. You have already reduced the value of her work in the house as a housewife, which too is problematic. There is no reason why he should have an extra share because he is the dominant work, because we are correlating it with her role, which enables him to earn whatever he does. But her role is not just enabling and therefore less valuable. Her enabling role should result in equal monetary value when it comes to making her claim against him. That was also the problem with Anurita Bora, which was, may I say, a landmark judgment even at that time. Because at that time, the lawyer for the husband was arguing that she should only get 1/3. And the judge said, look, there is nothing about fractions over here. So we have to look at the resource case and divide it in the following manner. But my issue is that in the conversation with regard to equal shares, in the conversations with regard to equal share for a woman, then there is no reason why she should have half, only because she does not earn money directly. So the Madras judgment is remarkable that it deals with this issue of direct and indirect and says the work is of equal value when we have to compute it in terms of money, in money terms. Now, what I am saying, when we change the default position that I'm asking, that I seek to argue for, I realize that one has to do it notwithstanding the legislation. Because the legislation itself does not align with my argument about the default position. So therefore, the argument has to be that we have to persuade judges to come as closely to the position of equality within the constraints of the legislature, of the statute, which for a starting point one has to see is ridiculously dated. It's 1956 and 1954 when we talk of the two statutes, Hindu Succession Act and Hindu Marriage Act and Special Marriage Act, and no other personal law I'm talking, because then we are going into some separate rabbit hole. But right now, with regard to these two statutes, if we treat these as the parameters, then both these statutes, and I won't spend time reading it, all of you would be familiar, but I'm just broadly saying, do you have the act? Broadly saying that interim maintenance as well as alimony is premised on that the wife is unable to maintain herself, which means wife is unable to maintain herself and does not have any independent income. So she's not able to maintain herself either by working or does not have the income to sustain herself. Then she will ask her husband. So in that context itself, the prerequisite of inability to maintain herself sometimes puts a heavy burden on the wife. And I have argued this on behalf of the husband too, to say that what, therefore, if you are unable to maintain yourself, that's when the court stepped in and said, unable to maintain yourself has to be in accordance with the lifestyle. So you may have enough, which is, a roof and shelter and clothing and so on and so forth, but we are not talking of abject penury, or that's not what we are talking about. It's all relative, and we have to look at it in the context of lifestyle. But even though the meaning of prerequisite of unable to maintain yourself has been rendered somewhat moot by subsequent incorporation of the lifestyle rule, which is again an evolved jurisprudence, as it has evolved by the law of precedent. But the truth of it is, the very wording of it is still a asymmetry with regard to the value of her work and her claim. Because the position is not that she has a right of maintenance and alimony if she is unable to maintain herself. The position is that there are certain property rights that accrue within a family unit because of what the couple set up together. That work, whether it translates directly into money or is supporting to enable money to come in, is besides the point. The point is that when it comes to sharing, then it is equal. And whether the title to the property is in the name of any one of the spouses is immaterial. The presumption is that the other person too, the other spouse too, in fact, has a right and interest in the property, notwithstanding the title. That's really the focus that we need to adjust for this to become meaningful. And all of this, the Madras judgment has managed to do, which is what is absolutely remarkable about it. So we have to keep reasserting all of this again and again to be able to minimize the counter rulings that are bound to happen. This will go in appeal. I don't know whether this is a single judge. It'll go to a DB and so on and so forth. Some conservative judge may well read it in the context of maintenance laws and say that kind of equality is not envisaged. We'll have to be prepared for the counter to that. And for that too, one has an argument under the Family Courts Act today, because the umbrella is the Family Courts Act. These statutes are within that umbrella, and a suit under Section 7 of the Family Courts Act could well be maintainable for declaration of such properties, dehors maintenance and alimony rights. That's the exciting area, the exciting possibilities in this area, and the exciting possibilities of the Family Courts Act. So therefore, so far, what I have tried to present is Madras High Court is remarkable a judgment because it has visibilized women's labor, not just visibilized it, but given it an equal value, something that judgments in the past, even though remarkable for that time and their time and continue to be so, have still not done to the extent that this one has, because for the first time, this one recognizes indirect title by virtue of contributions, a direct title by virtue of financial contribution made indirectly. So it is unprecedented from that perspective. And yes, we will see what happens in the future, because this would be in the context of maintenance and so on. But the truth of the matter is that the Family Courts Act will give us that exit clause where we will say, never mind 24 and 25. And that's the conversation that will begin with regard to women filing suits on the ground of equality in family property earned by their contribution to the family resource cake, which may not be a direct financial contribution. So this is what I have said so far. I also say that all of this needs to be done in the context of, if we address default position as being if we address the default position and always at the start of any conversation look to that, and if we look to that to see how are we truly equal in that default position, then argue. The husband's lawyer will have to argue away from the default position for good reason, while the wife's lawyer will argue to maintain the default position. That's that, rather than the default position being asymmetrical and the wife's lawyer always having to justify a better share of the resource case and almost never as equal. In that, while looking to the default position, we have to see perhaps one way of, just when we introspect, we'll have to see how do we value the wife's work, the woman's work? How do we value the and most of the time we tend to, like I said already earlier, tend to treat it as enabling and therefore less valuable, only enabling, best supporting actor or something. But it is actually equal. It is actually equal. And the depth of it, there are a number of reasons. Now, here, since I've been asked to comment from a court perspective, I will tell you one of the important areas which traditionally have always been, that maternal preference, her rights to financial equality because of her role of bearing and rearing children, the most obvious one. So I have had husbands' lawyers nowadays in two important cases, which I did recently in the last 2 years, argue that that preference is not available to the wives in my case, who are my clients in both, because the children were born from surrogacy. Because the children were born from surrogacy, the argument is that she only has the egg connect, but the labor is not there. And therefore, the maternal preference rule should not apply to her. The father can be as much, is exactly the same. But when it comes to finance, if we go by this argument, it is that yes, the women need to be compensated for the labor of childbirth, and which should give them protection and so on and so forth. Then what about surrogacy? And truth of the matter is that it's obviously those husbands, lawyers, I mean, they were men, because they did not understand that, frankly, the pain of extracting an egg for surrogacy is probably more than pain of childbirth, may I say. So if we actually have to value that, the burden of even extraction of egg is still huge on the wife. It's a continuous treatment. It's so many injections. It's an alertness required. It's then painful insertions, penetrative process to pull out the egg and so on. And the husband's job continues to be the same either way, whether uh, in a cup or otherwise, so to speak. But if we are translating it into labor, hers is no less. But what I find ironic and makes me angry, may I say, is how quickly every argument is used to try and reduce her claim, which for the woman is never more than just equal. That's the point. So the idea is always all right, then so it is their default position is always only patronizing protection. And yes, you can say that you go through labor pains, but that doesn't happen anymore because of surrogacy and the science has, and so on and so forth. But the truth of the matter is, it actually doesn't change what she has to go through. And we come to this almost absurd narrative where I have to explain even here, and I had to think about it, of the pain of the process of surrogacy, where the weight of it is still more on the wife from whom the egg has to be extracted. So we shouldn't even have to go in these realms, because it becomes it's undignified, and it is unconstitutional, because the starting point therefore has to be 50-50, with no justification as to it is 50 because of the child and labor and so on and so forth. If there is he might call her slothful, she had a army of staff who did everything and so on, and all she did was watch TV through the days, besides the point. I mean, I don't want to get into those absurd areas, because it is an amalgam of work done as expected in a matrimonial relationship, which is the consequent of a dual legal relationship. Then it's not about her competence and incompetence. It is about her share in the earnings. And given that courts are already overburdened, and we are trying to streamline and get justice fast and finish fast, and matters to be disposed of expeditiously, it would be much better to start with the constitutional position of, yes, they are equal, give us good reason why it shouldn't be so. Now, so therefore I am saying that what is the compensation for woman's labor? Rather than getting into even that, paid, unpaid, visible, invisible, yes, we've come this far because of this conversation. Now the next step has to be, we need to cease to justify it. I shouldn't have to talk about childbirth versus surrogacy, but it is distressing that I still have to. So we have to get past that. And then, therefore, her work is not half of what he does only as a supporting, is what I want to say. So the presumption, therefore, has to simply be that here is a family unit that needs to be sustained in a certain manner, and it is done by the work of both spouses in various forms. It could be in separate spheres of domestic and outside. It could be in the same spheres. It could be in converse spheres. It doesn't matter. And therefore, when this unit is being dismantled, then the allocation of the assets of that unit have to be equal. And here, after all, if we are talking of co-parenting plans, where the father should have 50% of parenting time as privilege and so on and so forth, then there's no reason where this other asset, which is also developed by the unit, which is money, should also be divided in 50-50. That's the point. And that is equality within a marriage. So words as done in Anurita Vora, which is of dominant earner, have to be removed. And of course, I mistakenly was talking to Shreya, who has worked with me for this lecture, and I told her, well, Lord Denning was so much ahead of his times when he, talked about the work in the home that entitles her to rights in the matrimonial home. And so Shreya has kindly done some research for me and found a paper which talks about that even the best of judgments, which recognize a woman's rights still come from a position of patronizing patriarch, where the point is that she is getting paid for a job well done. And if it is not well done, then she's not, which is why under our alimony, in our statutes, conduct is still relevant. And so much time goes in establishing, foisting fault upon each other to assume the person with the better conduct and therefore deserving of more money for the wife, or that he should pay less, and so on. So here what Shreya found for me is very and this approach of dominant earner of Anurita Vora is no different from the words of Lord Denning in 1969, where he states that women ought only to acquire rights in the matrimonial home when they have done something to merit them. Thus, Mrs. Button, and that's from a case Button versus Button, does not get a share in the house simply because she cleans the walls or works in the garden or helps her husband with the painting or decorating, as those are her expected duties as a wife. But Mrs. Cook, and that comes from another judgment called Cook versus Head. But Mrs. Cook, who uses a sledgehammer to demolish buildings, paints, barns, sorry, okay. You paints, barns, and works the cement mixer is entitled to a share in the property. So, meaning thereby that we have to move beyond the position of her justifying her claim. We have to move to the position that the claim is there. And if it should be less than equal, the onus shifts on the husband to justify that he needs to not pay in the pay an equal half. And this is what must be. So these asymmetrical presumptions have to be discarded. The presumption has to be equality. And then for it to go one way or the other, it is for, she may well have a claim that is more than half. So then she'll have to improve that case. And he, of course, invariably will have to justify less than half, that he wants to pay less than half. And of course, for the husband's lawyer, the statute, the way it exists at the moment, is very easy. It justifies his position. Because the onus is on her first to say, I don't earn, and that I have no independent income. But even if she does a bit, even if she has some independent income, it seems to operate against her, number one. But that prerequisite pushes the onus again on her to justify almost to justify the equality, to justify her claim even in the first instance. That's where the problematic lies. So now I'll just wind up with one more thing, which I would like all of you to think about, because I have not, and we've been looking at this. The old Benami Prohibition Act. No, but it wasn't used. Old Benami, they're saying it's not gone into it, but it's mentioned in the, because you see, in the Madras judgment, there is a reference to the Benami Transactions Act, and it is one of the defenses that the wife took. So rather than, the wife took all the defenses available to her, which is that it is untrue that I don't have an independent income which contributed towards the money. Because obviously it's very bold suddenly to say, yes, you are right, I earned nothing, I got it, but yet I'm entitled to. So to be safe, she took all of her objections, and that she used to give tuitions and so on and so forth, and in that manner contributed directly as well. And then she has used the old Benami Transactions Act definition, wherein property purchased in the name of a wife or a daughter is not a benami transaction. However, what does that mean? It means that the husband says it's not benami, it's still mine, albeit in my wife's name. But the old act actually brought in something, a layer of protection for the wife, and used an opportunity to give her a substantial right. Where the old act said, yes, it is true, property purchased in the name of the wife and daughter is not barred by Benami Transactions Act. However, if a husband wants to assert ownership of it, he has to deal with the presumption that it was purchased for the benefit of the wife or daughter. So the opportunity was used by the legislature at that time to create, in this constant uh, dialogue about better rights and property for the woman, the opportunity was used to give her this substantial right, not just procedural, to say there is a presumption in your favor that it's bought for your benefit. Come the new act, which was passed with this new government in 2016. The new act has retains that property purchased within transactions within a Hindu undivided family and so on and so forth are not Benami transactions, and therefore they can be dealt with. But this presumption has been removed. So the removal of the presumption is just a silent stripping away of it seems to have not been debated at all. We've been trying to look for conversation around this in a 50-page analysis. And in fact, this was introduced by the late Mr. Jetli. There is no conversation as to why this presumption was dropped. So from that perspective, once that presumption existed as a legal right in her favor or in favor of the daughter, then surely there has to be a justification for this arbitrary removal of that presumption by the so-called amendment of 2016 to the act, but really speaking, it's a whole new act, and so the conversation, therefore, we are looking always for, to build on the conversation. We identify spaces, we connect those dots to build our facade, our structure of better legal rights in property for women, not just better maintenance rights, but better rights in property for women. Then even such seemingly unrelated, like in the Benami Act, that just sank like a stone quietly and is not being discussed. We need to bring that back and use all of these opportunities to improve and have dots closer together to be able to make a stronger edifice, to demonstrate. And for that, I come back to where I began from, that our starting point is going to have to be different. Our starting point, even when we make our own case, will have to be with the introspection that, yes, she's an equal earner, whether it translates into currency or not. And assets that are built over the marriage are because of that contribution. Call it indirect earning if you like, but I say remove even those terms. Justice Denning did try to bring in the trust principle, so we'll have to look to trust law also. The family unit is by virtue of the relationships that are formed, putting each other in fiduciary duties to each other. So we have to bring in those trust laws. And those trust laws are laws by themselves which can be brought into operation without the working of gender. There is no reason why the law of trust should work. The trust relationship is less for a wife who's not earning or more. It is the same. You are a organization. You become a legal organization when you got married and set up a family, which then by the workings of these various matrimonial laws and all these bundle of rules, including the meaning of trust obligations to each other, all stand in a equal fiduciary capacity to each other. And I'll round it up by just 2 more minutes to give you just my own. You see, all of these things, when we talk, it sounds it's luxurious to talk of trust law, etc., because you can talk of those things only if there is enough money. If you're talking in a family structure which is just middle class and liquidity, financial liquidity is a problem, then we cannot use those cases to develop the law. After all, even in this case, the law has developed because the man went to Saudi Arabia, earned obviously a large amount of money, which made those investments, because that is how you can earn better salaries in that part of the world, which you send back for the betterment of your family. So most of these kind of laws will develop where there is enough to go around. And we are then talking of enough to go around where it should be equal. So we have to look to the high net worth cases actually to developing the law, the principles of law that can then be applied through all the layers, right down to where, unfortunately, of course, there will be a reality where even divorce makes no sense because there's just not enough for one pot. But that's again a separate, we'll be going somewhere else. So in these larger net worth cases that I am arguing, and I want to tell you one recently, the husband set up a trust and so on, where actually by the trust document itself, the wife is an equal. But subsequently, because it is he who has moved on, he's now trying to renege from the position of the trust. So I am saying, okay, in this case, at least there's a trust. But those same principles can be brought in when property is acquired by a family unit. How much of an individual is there when you are a husband and a father? Can it be that you are earning for yourself alone to the detriment of those with whom you are in a fiduciary duty and obligation to, which is your wife and your children and the family unit generally? And the law of trusts and the concept of rights and duties has to come into operation to show that, yes, the default position has to be equal. And why I'm referring to this particular case is because they have a battery of extremely, just think of the big names at the moment, and they're all there for the husband. And the way they were talking, at one point I was angry because it was almost as if they were retiring a long beloved nanny or a chauffeur. Yes, we will be looking after the insurance and we will be looking after, she will have a very good car, she can, we'll get her a house on the same, within the posh area that she lives in and so on. And I said, look, we are not talking pension here. It's not about the amount in eventually that we have asked for. May I say, it took me courage to even articulate it for myself. And that is again an introspection that I have to do, where I have to assert equally and not be embarrassed about mentioning large amounts of money just because I would say, oh my God, does she need that much? Of course, it's not about need. It's not even about a want. It is about assertion in the default position. Treat it like a large business house where the two partners are now separating. They will separate, as Justice Sridevan has done, and bringing in that the partnership quality. Then it has to be. It doesn't matter the amount. Is X, X plus 1, X minus 1, doesn't matter. But it has to be equal. And that default position is where we have to work at. I think... really, I've been through my notes and this is all I have to say. And if there are any questions, I'm happy to answer them.
Thank you so much, ma'am. That was really, really insightful. And yeah, I mean, I think reading your book and hearing this has just opened up like a whole sort of different way of looking at unpaid work, even for me and for the project at large. So we're really grateful. And yeah, I mean, now we can move to Justice Sabha for her comments. And then we'll, of course, take questions. I'm sure folks will have a lot of questions, and I also do. Justice Sabha, are you around? I think you might be on mute.
Yeah, she's on mute.
Yeah.
Can you
I'm
hear
just going
me
to
now?
stop my camera for 1 minute, just for one
Yes.
minute. Thank you.
Can you hear me?
Absolutely.
Yes, now we can.
Yeah. Thank you very much for tracing the history of how women's equality has been ignored, let's say. You mentioned only the Hindu Marriage Act and the Special Marriage Act, right? So I will also refer to the Hindu Succession Act, Section 15. I'm sure that Narayani Devi's case, where though she earned, the Supreme Court said that her estate will go to her husband's heirs, because that's how the Hindu Succession Act reads. Because women are not owners, instead of which they are just intermediate. So what comes from her husband goes to her husband's heirs. What comes from her parents goes to her parents' heirs. It's as if she is not an active agent of her own property. Though in that case, Narayani earned her property. She was not, within quotes, unable to earn. She was able to earn and still it went. So the idea of women owning property and women being paid is slowly but surely coming. One comment I should make about many of the judgments is most of the judges come from a particular background, let's say middle class. Minor Deepika itself talks of a middle class woman. It's not about a non middle class woman. So that disclaimer must be there. We must recognize that there are other kinds of unpaid labor, which is physical, which is, I mean, maybe she helps in the farms, maybe she helps in the fields. So there are various kinds of unpaid labor for which recognition is not accorded. And let us say that in a household, one partner goes out to work and maybe earns more money. The word dominant partner, with that word, probably it is used because the money that person brought in was more. I don't know. And let's say the other partner brings less money, or perhaps she uh, she is at home. Anyway, we can look at it as a division of labor in which everything must be divided equally. If one component is A, the invisible component is also A. It's not less than A. So that is something that we must recognize. And about my using the word justified in that judgment, I used justified because this was a case where I had to say there is evidence for it. Without evidence, I cannot quantify some amount for Deepika's mother. So that is why I use the word justify, because fortunately, in that case, the father-in-law, that is Deepika's grandfather, had given evidence that his daughter-in-law had helped his son. So we could, I mean, I cannot build a case on air. I need evidence. So that is why That is why we use the word justified. And as regards this word unable to maintain herself, I was just thinking, can we use that inability as a constructive inability, just like we use for constructive desertion? It's not her incapacity. She does not do it because of other circumstances, like she is at home. So it's no reflection on her. It's just the factual statement that she did not bring something that we can quantify in terms of money. And now we have to quantify in terms of money if we have to recognize her equality, which we should. And the Kannaiah Naidu case is remarkable for it deals with how the value of that unpaid labor can be assessed. And in minor Deepika, we had said that this principle, we had given 4 ways of calculating her worth. And actually, Kannaiah Naidu uses one of those modes of calculation. We had said we hope that this recognition of women's work would be extended even to maintenance and matrimonial issues. Disconcertingly, I thought that till now it was only used for motor accidents cases, and I'm so happy that it has extended to, I mean, the jurisprudential field that has opened, and it has, yeah, there is some more to go. And as Malavika said, we always have to be fighting to retain what we call the default clause. The default should be automatic. It isn't. We have to fight for the default. And for that, I think if every judgment mentions all the judgments that went before, then the body of judicial precedents will build up, because we are essentially a Commonwealth law. I mean, we follow precedents. So it will. So I'm very happy about this Kannaiah Naidu case, and I'm very thankful to Prabha and Amy for inviting me to take part in this discussion. It is really lovely. Thank you very much, Malvika.
Thank you, Justice Sridevan. Thank you.
Thank you so much to both of you, and thank you so much, Justice Sridevan, for those comments. I think, yeah, it's really nice also to be able to have a dialogue like this and to participate in this and to see, how the law develops, to see how all of you folks who play such an important role in the law developing the way it does, to hear your comments on this and to actually have you be able to speak about a judgment that you authored, I think, in this context is absolutely lovely. And personally, I mean, as a researcher now, I just had one thing to say, which is that, yeah, I mean, we all get super excited when there's a case, when there's an order that cites all of the other orders and actually sets out the law for us. Because then we know that, here is somebody actually trying to make an argument that we can also look to at a much future date, which is, today when we're reading a judgment like that, to actually make our arguments as feminist academics and writers. So, yeah. And yeah, now we can open up for questions. So if anybody, yeah, you can just raise your hand and I can have you. Yes, sure, Professor Taptish, you can go ahead.
Hello, Malavika.
Hi,
Long
Saptarshi.
time.
I just read a very nice article of yours. My son had forwarded it to me recently on family law. Very nice.
Thank you. Question about the default position. I mean, changing the default position that you're talking about. I'm a little uncomfortable with this argument, and I've kind of raised this point at this forum earlier also. It seems to me that we are trying to do the work of matrimonial property through maintenance. So in my understanding, maintenance, the scope of maintenance law is very narrow. We've been talking about the Deepika case, but in Deepika, the context was to compensate this woman, compensate this woman's labor. In maintenance, I mean, maintenance does not follow the logic of compensation. Maintenance is supportive in nature. So there, if you are trying to make this equality-based argument, then how do we, then it requires us to kind of reconceptualize maintenance as
I
something
agree.
else. So, and if you're making that, the other conceptual difficulty that we run into is how do we use this labor argument in the case of, say, maintenance for children, maintenance for parents? Or are we saying that we have one theory of maintenance for the spouse and another theory of maintenance for the other members of the family? So this is
Right.
not to disagree with you, but just to, in
No,
the
I
spirit of
get
kind
it.
of
I get
brainstorm.
it. I like the point. I like your question, and I don't disagree, may I say, because even during the course of the conversation, I did say that 24 and 25 in any case, or the equivalents under the Special Marriage Act, in any case are very narrow. So I agree with you to that, because it's about equality, inability to maintain yourself as being maintenance perdante lite. And then comes alimony and stroke maintenance under 25 and permanent alimony. So there's a difference. There's interim maintenance where I would say, yes, there must be enough just to, we can't go into the detail then. But when we are talking, but even to get past 25, for example, alimony and maintenance, which you say is only supportive, I kind of disagree there as to what alimony means. I feel that the words have been used interchangeably, and that is incorrect, because the alimony has to include the compensation component as well. So when I talk of the default position, I mean it not pending litigation, which is 24 and 36, I think, of the equivalent of the Special Marriage Act, but I mean alimony / maintenance or permanent alimony under Special Marriage Act. Number one. Number two, of course, you will know that under the Special Marriage Act, there's a problem that needs to be addressed, which is that Hindu Marriage Act is gender neutral. Either party can make a claim on the other. But under the Special Marriage Act, it is the wife alone who can make a claim. So that will have to be rectified at some point and, struck down as being unreasonable, and there's no classification and so on. But coming back to your point, I agree that I am trying to I have brought in the concept of matrimonial property, and in the concept of matrimonial property, which again, during my talk, I had said that there is the umbrella of Family Courts Act. So it is quite possible that I could file Section 7 suits under Section 7 asking for declaration of certain properties. And that would be any residue claim which is outside 24 and 25. I have mentioned that. So it's a question of how we use it. But having said which, in 25, by itself, when we talk maintenance, we will have to think about what does alimony mean? Does it include, is it only, to my mind, alimony means division of properties, and we can, rather than waiting for the legislature to refine and reform, which given our experience seems further away than ever at the moment, then I do believe that perhaps it's better to innovatively use what we have to get the best that we can. And that is possible by using these routes. So 25, yes, we can use for rights, which is not limited to maintenance and support. Section 7, we can use to assert equality. The case that I'm talking about, where I've used the trust argument, is a suit that I have filed. We've not even gone into a divorce court. But I agree with you that when it comes to sharing the resource cake, then what are the rights of children? Are we how can we equate it to labor? And what are the rights of parents? How do we equate that to labor? And in fact, that's exactly what I'm saying, that we should not be talking. Default position has to be that you have structured this, participated and created by a legal ceremony, this structure, which is a family unit. And now we have to talk about the politics of equality within that unit. I don't want to count pennies and count labor. That's what I meant.
Just one additional question. Could you share the title of this case, the Section 71C Family Courts Act case that you've been referring to? Could you just cite? Could you just tell us the name of it?
I've only filed it.
Oh, okay.
I've only filed it. I've got an interim injunction in my favor. I can share that judgment with you. And of course, we've done well by virtue of the interim injunction, and we've gone in appeal, and DB has sent us to mediation. And may I say, that's exactly what I'm dealing with in mediation. It's before a retired Supreme Court judge who's asking me, how will she spend so much money in her lifetime? That's not the point. That's not the point. Nobody asks a man how he spends, how much he earns, whether he spends it at all in his lifetime.
Thank you.
Okay, I just want to say one thing to Saptarshi's use of the word compensating. The word compensating in Deepika's case is both for father's death and mother's death.
Yes.
So what we are talking about is when I say loss of the father and I give a judgment, I speak of his earnings. So how do you speak of her earnings? That was what was the issue there. What did she bring home? If you can use that kind of a phrase. What she brought home.
And to build on that, I also want to mention that in any case, for the first time, a compensation as a claim in a tortious wrong has already come in with the Protection of Women from Domestic Violence Act.
Yeah.
In any case, also.
I think we had a question from Bhavna who seems to lower her hand. If you'd like to go ahead, Bhavna, you can. Or if anybody else has a question. Yeah, Prerna, you can go ahead.
Hello. Hi, thank you. I don't have a question. I just want to say thank you for this very informative talk and session. I'm an advocate and right now I'm with NLU Delhi, but before that I was a judicial law clerk at Supreme Court for 2 years. And, I completely agree with what was said about the precedents and, what was said about a judgment having all those orders, all the previous judgments remain, so we can have a good look at how jurisprudentially this has evolved. And also Malvika's it gave me a whole new insight on how to look at this area, which I did not have before. It was really eye-opening. So thank you so much. That's all I wanted to say.
Thank you for saying that.
Sure, go ahead, Prabha.
Yeah, thank you so much. This was just incredibly interesting talk and observations from Justice Sridevan and Malavika. I guess my question was about matrimonial property, because, there was within the feminist movement, at least 10 years ago, a very firm belief that one could propose reform in the area of matrimonial property, and, drafts were drawn up and considered and debated. So I just want to, I mean, irrespective of the sort of political environment, I just wanted to ask about, how that conversation can be kind of recovered, or how we can push forward in that respect now, and what kinds of creative, I mean, obviously there's creative lawyering, but also what kinds of creative scholarship can begin to join the dots, as some of my colleagues would say, prefiguring, different kind of reality, an economic reality for women in India.
Right. Yeah. I mean, one is, of course, the judgment of under the Hindu Succession Act with regard to the amendment of Section 6 on the claim of a daughter as a co-partner. Now, that has been with retrospective effect and so on, and that's important. But I have an issue which perhaps it requires scholarship on which does, I mean, everything does require scholarship. But my point is that once again, with the daughter getting an equal share, and I'm not against that, but I'm just saying the unwitting consequence is again marginalizing the wife. So the daughter is a co-partner. It therefore cuts into the share of the brother with regard to his rights in the co-partnery. And the wife in any case is not a co-partner, and if there is a partition, then the wife gets a share that is equal to her husband. That is there. But in the conversation, the wife gets marginalized. That's one side of it. You can have instances where all of these important steps are being taken to financially empower her, which I think, I mean, obviously nobody can disagree that that is good. But the other consequence of it is that there have been instances which I have been noting in my practice, and I have cited it as a ground for cruelty for divorce, may I say, which is that husbands of well-to-do wives who do not wish to deprive their husbands of their brothers and parents or their fathers of co-partnery rights by asking for a partition in their lifetime are being pressured by husbands to say, ask for your share. So the conversation, practically speaking, is not with how much money she can eventually be entitled to. It's about control over that money without it negatively affecting her relationships. So there are all these changes that are happening even while traditional structures which are patriarchal remain. Co-partnery is a traditional patriarchal structure. Marriage is a traditional patriarchal structure. Societal pressure about it is a traditional patriarchal structure. And within that, to empower with money, and I'm not saying it shouldn't be done, it should be, but we need to see how to deal with then not having her become literally, like, for example, dowry originally was supposed to be the woman's property, but eventually she only became the means for the husband to have property. Similarly, this section 6 gives her rights, but it, in her matrimonial home, she eventually becomes a means for the husband to have more money through her by asking her to claim from her mica. That's one part. The other part is that the wife, who may not be from a rich home, is losing out to the nanad's claim. So all these modern egalitarian methods within traditional structures is resulting in skewed dynamics which are not being addressed. I think my answer is longer than your question, but but you get what I'm saying?
I agree with you, Malavika. We are trying to fit a square peg in a round hole and it's not working.
Yes.
Any other questions? Oh, Lara, you can go ahead. Lara, you can go ahead. I hope I'm audible.
You're muted, Lara.
Yeah. Okay, maybe they had some internet issues. Uh, yeah, I'll actually go ahead and ask a question then in the meantime while we wait for anything else from anyone else. But
Yeah.
yeah, actually, in the context of Professor Saptarishi's question, as well as our broader conversation around maintenance, I was really hoping, because this is something we keep coming back to in our writing and research as well, because we've been looking at personal laws across all um, the religions, as well as trying to, understand, of course, the relationship between that and Section 125 or the DD Act, how they play in. So I was hoping you guys could just talk a little about just sort of this understanding that there in Section 125 and the DV Act, which I feel like in a lot of judgments pores over, though it actually does not need to, as per jurisprudence as well as the letter of the law itself. The fact that under the DV Act or under Section 125, the maintenance that's being claimed is for a situation to do with where somebody is in penury, or they're really unable to support themselves, and so it's actually just supposed to help you tide over a particular type of time and not be a settlement of rights of any kind. Just even by the procedural nature of like a CRPC proceeding or a DV Act proceeding for maintenance, where
Yes.
it's the nature of the legislation and the provision itself is such. So yeah, I was hoping you could talk a bit about, what you see in terms of the jurisprudential or otherwise overlap between that and the alimony provisions, because I feel like in a lot of the law that we've read, that sort of understanding gets borrowed. Um, and even interestingly, like Malvika and I were at a consultation that Vidhi had recently, and there the maintenance provisions again sort of look to Section 125 as a benchmark setting provision, though the section will continue to exist and serve its own purpose. So yeah, I was just hoping you guys could speak about that a little bit.
No, so the question is how 125 DV being situation specific of urgency, how they harmonize in the fabric of other maintenance laws. Is that the question?
Yeah, how they harmonize in the fabric, as well as this sort of, I just the fact that, I mean, the way I read it, and I want to know if that's how you are reading it as well, given your much obviously greater experience.
I read it the way you are reading it, but the truth of it is that Rajesh versus Neha does not seem to have done what I feel. It did not realize its full potential. It was an opportunity to actually deal with 125, particularly as being an interim urgent mention. And the problem is that 125 is filed as if it's like any other civil proceeding, and they all run into each other, and we lead to multiple proceedings, and which again does a disservice to a wife's claim. So 125, if it didn't require such detailed trial, etc., and based on prima facie summary position, you came to an arrangement with regard to maintenance, uh, would serve better. And then we move into the realm of the civil with regard to, but very often the reason why 125 is filed, because wives sometimes may not want to file for divorce. So then, of course, you have the issue of filing for maintenance. Problem of filing for maintenance is then a suit for maintenance requires a prohibitively high court fee. So that's a deterrent in itself. So Maharashtra has an exception where no maintenance suit requires a court fee of more than 15,000. Whereas in any other state, in Delhi, for example, I know that it would serve well for me, for many clients to have filed a suit for maintenance, but the court fee, we end up dealing with so much time because she has to file as forma pauperis to how to establish that, years go by. So systems have to align with what is the substantive law, what is the end goal, and what is the procedure in between. And the procedure at the moment is so knotted that the substantive law hardly ever translates into anything meaningful at the end. So we need to work on procedure for that. And the Family Courts Act did do that. Because when Section 14 came with regard to streamlining evidence, no reason for affidavit of evidence, judgment, and so on, Family Courts Act has done it. But again, the default position is the traditional adversarial position, which pits them against each other. So the newer position of the family judge, which is also part inquisitorial, has not been encouraged enough even by the Supreme Court. And that's where a judgment like Rajesh versus Neha, I feel, did not, the opportunity was not used, and it was a chance. Like, for example, Kusum Sharma, what Rajesh versus Neha with affidavits actually did what Kusum Sharma, which was truly innovative, Justice Midha's judgment about details of affidavits. That was already there. And in fact, the detailed affidavit now under Kusum Sharma was far more insightful, and the forensic possibilities to analyze were much more than the newer affidavit which has been advised by the Supreme Court. So there needs to be something which is not done in autopilot mode, by actually addressing the issues that we need to do.
Thank you so much for that. I think we have a question from Sarah as well. You can go ahead. Yeah.
Yes, thank you so much. This has been very enlightening. I'm actually a lawyer based in Karachi, Pakistan, and that's where I practice family law. And you may be aware that under our law, there's no recognition of the existence of joint marital property. And what instead ends up happening when a marriage fails or breaks down is the husband often files these benami suits, which you also mentioned earlier, in cases where the wife is either the full owner of a property or even where she's the co-owner of the property. And those cases are allowed, and even eventually where, and there is sort of these standards that the court has laid down to assess whether or not the property is benami. And often, eventually, you see that women do win these cases. However, it's a civil suit. So the suit takes years and years to proceed. And in the meanwhile, the woman is dispossessed of her property. And these cases are extremely common in our jurisdiction. And so I just wanted to get a little bit more from your perspective about how, you mentioned these cases, about how these cases are now being dealt with in courts in India, whether there are kind of progressive interpretations of this Benami principle. We also recently had a Benami Transactions Prohibition Act, which defined Benami transactions in a way that excluded claims made by spouses. So when we have made this argument in court to say that now it doesn't even fall in the definition of Benami, so it has to be considered real ownership, courts have rejected that definition and said, no, the exception means that husbands can continue to claim Benami, but in all other cases where it's not given to the wife, is prohibited, but giving it to the wife as a benami is prohibited and so will not be recognized as real ownership, which I don't think is the correct interpretation of the law. So just one question, get to learn a little bit more from you about your experiences with these cases. And then secondly, if you could talk a little bit more about how in cases dealing with Muslim communities in India, courts have looked at marital property, because while we will try to use, Madras High Court judgments in courts here also, and I hope, depending on who were before, this will have a good persuasive value, but courts that are judgments that are dealing with Muslim personal law in India are more likely to be persuasive for courts here. So just wanted to see if you can give a little bit of insight into how in cases of Muslim personal law courts in India looking at claims of marital property.
I'm afraid I'm not going to be. I wish I could answer that question. If you give me some time, though, I mean, I'll think about it and get back to you. But straight away, I have nothing that comes to my mind with regard to a ruling on Muslim personal law and a woman's right to property within that. But increasingly, yes, we are using our Family Courts Act to assert these claims. And much like in your country, we are at the end of it just mirroring each other in terms of legal regimes in so many ways. Much like that, it's one thing to have filed it, and like in your country, we are waiting for outcomes, and most of the time we use positions of filing to put our ducks in a row, so to speak, which then a good counsel on the other side who's actually interested in closure, which very often, as you know, everybody isn't, would be happy to actually use those ducks in a row to then negotiate and leverage, and we come to a settlement. But so unfortunately, what translates into path-breaking judgments and precedents is those that have gone through the mill of horrendously tortuous routes, isn't it? So that's a reality which we are dealing with as well. But I'll certainly keep your question in mind, Ms. Balkani, and I'll be happy to do some research for you and get back to you on that. And I'd be very interested in your experience of using the Benami Act. What you've said has interested me greatly, that there is that exception and yet that interpretation. So that would be, but the problem in our act is that our old act created a presumption, but the new act, presumption that it's for the benefit of the wife or daughter, but the new act has not.
In that regard, this is what I'd like to suggest.
Ji.
See, the Benami transactions, except with regard to wife and daughter, are prohibited because the person never intended the title to go there. It is a fake transaction, that is why it is criminalized or prohibited. Whereas you can argue that when it's the wife and the daughter, it was meant that they should be the owner. That is why the act did not prohibit it. Then they should be able to assert their right, notwithstanding the deletion of the presumption. But it will require argument, and it require about 30, 40 cases to build up that position,
Yeah.
I'm sure.
Yeah.
I'm being very optimistic saying 30, 40, but anyway.
I think we'll take a last question from Lara, since she's been trying to ask for a while and got disconnected earlier. And then we can wrap up, since we've had you guys with us for such a long time also. We're very grateful for. Lara, you can go ahead now.
Can you hear me now?
Yes, we can hear you.
Perfect. Thank you. I had some technical difficulties earlier. I've really enjoyed your talk and I found it absolutely fascinating. I wanted to ask you, kind of in a different tangential direction, how you think it could possibly be these kind of interpretations could be transferred to cases outside of a married setting, for example, in single parent families, etc. I guess it's probably going to be less protected under the current system, but I don't know if there are any ways in which this could be approached.
Yeah. So, well, under our Protection of Women from Domestic Violence Act, a relationship which is outside marriage, which is a live-in relationship, is protected, and there are rights of residence, though. There will be no question of, but not built up marital asset equivalent, but certainly just rights of residence and maintenance and so on. So it's a little early and very too basic. According to me, the live-in relationship factor has its own problem, which I would like to use this forum to just air. The Indra Sani case, I think it is, or Indra Sarna case, I can't remember, which one, a Supreme Court judgment, basically has said that when we say live-in relationships are covered, it means relationships in the nature of marriage. Fair enough. A couple decide that they don't want to marry and they want to live together, and then they have children or not, have rights and so on and so forth. And the Act steps in to protect only at a basic level with regard to domestic violence. But already in the case that I mentioned, Indra Sarma case, Supreme Court has said that where the woman is living with a man who's married and she knows that he's married, then she cannot claim protection under the Protection of Women from Domestic Violence Act. That for me is deeply problematic. And that is again pushing back at the system. The system, in fact, constrains. Our cases take forever. I have been constrained to advise clients you cannot define your life by your case. Therefore, if the divorce has not come through, if you have to live with somebody, you please go right ahead. So sometimes the problem is created, which is a systemic problem. The divorce has not come through, so he is living with someone else. And yet that other lady, the second lady in his wife, in his life, who could be his wife if he was free enough to marry, would have that protection in any case. And this court doesn't, and the Supreme Court hasn't understood that nuance. So it is pushing you back into a very inefficient system, which is not translating into rights fast enough, and legislating and over legislating, and yet it's not making any difference in actual movement on the ground. So to answer your question, Lara, our laws are very basic with regard to live-in relationship. Registered partnership does not exist. Properties created together would then be deemed to have to be in equal names. Otherwise, the question of invisible labor and so on, it's an argument which is not relevant in a live-in relationship because we don't have the forum for it. And where we could have the forum for it, it has already been diminished. The working of the statute has been diminished by this particular judgment of the Supreme Court, which says that live-in relationship means only between two unmarried people. That defeats the very purpose of the Act. What does it mean that you can beat up the woman only because you're married? I mean, sometimes the results of these are very absurd and not thought through.
Thank you so much for that question, Lara, and thank you so much for the response, Malavika ma'am. It's been really, really great having you both here today. It's been really insightful, a very exciting talk also, and yeah, I join the rest of my team in saying we're so glad we do the sort of work that we do, so that we can share space with all of you and we can talk about things that are so important, so evolving, so nuanced, and create space for all of these conversations. Glad that we had a cross section of different types of professionals join us also today in terms of our audience. So yeah, thank you so much for joining us, and yeah, we will probably definitely bother you again in future to ask more questions and stuff as our project goes along, and hopefully have you to speak about more things again in the future.
Thank you so much.
Thank you very much. Thank you
Thank
all.
you.
Thank you.
Thank you, Justice Sridevan. Thank you, everybody. Thank you, Amala, Prabha. Thank you, everybody.
Thanks a lot.
And the talk will be available, today's seminar will be available on our YouTube channel. So in case you'd like to share it with anyone, go back to certain points, you can do that. And we host these every month, so we look forward to having all of you on more of them.
Thank you.
Bye.
Bye-bye.